So we'll go ahead and start officially. All right, so I'll pray first and let's go. Dear God, we just thank you for the blessings of another day. We know that, again, that's, there are different challenges going on. There's some good as always out of this, but lots of challenges in many, many different ways. And getting towards the end of the term, I just pray a special blessing on each of the students as they deal with their outside of class issues, and as they deal with finishing up a term, that they'll be able to get done everything that needs to be get done, and they'll be able to decide what they're going to do around the next round of classes. And just pray that the leadership at all levels, president, governor, mayor, everybody involved, we're making the right decisions, and that we'll all make the right decisions, and to do the right thing to hopefully at some point in time bring this whole thing to an end. We just ask this in your name. Amen. All right. Okay. So, all right. So a couple of you guys in hiding. Actually, everybody. Elmo's really in hiding. It's just different kind of hiding. So green screen hiding, I guess. All right. So we're going to do chapter 12 and chapter 13 tonight. And next week we'll do chapter 14 and chapter 15. And so that should finish us up unless something weird happens. So the week after that, basically I'll just need to have your final reports in by that last week. And then as I was telling Raven, we'll probably do the test on May 11th as scheduled. If we were doing regular classes and we were meeting like usual, and we were getting done early, then I'd give you all the option of doing it a week early. But with this, the way we're doing the online thing, I think they're kind of watching that sort of thing too closely. So what'll happen is on May 11th at around 5:30, I'll email you the test, and then you just need to get your answers back to me by 10:10, I guess, on May 11th. And then I can get the grades done and get them in. Enrollment, I guess, is enrollment started for the summer? Or?
I think it starts the 27th.
27th, okay, yeah, okay, so that's next Monday, because we got our schedule. So if anybody's interested, I am teaching marriage and the family. So social science, something or the other, whatever. Marriage and the family. Interesting topic for the 21st century, but anyway, so hopefully it makes, in some capacity, we'll see. All right, so chapter 12, again, I will tell you when you get the notes, there's one short answer question in chapter 12, and there's one essay question in chapter 13. Did we lose Alma? Looks like she went away there, so. She said she was having issues. Anyway, so I'll let you know when we get the note stuff. So we have one short answer question in chapter 12, one essay choice in chapter 13, and we'll have one question coming from next week. Okay. Alma's back.
Yeah, sorry.
Disappeared on us there. So. Okay. All right. So again, I'll let you know when we get the notes. So chapter 12 is on preparing for trials. Again, this is where I want to have the attorney come in and talk, but that didn't happen, obviously. And I will mainly about voir dire, but I'll still talk about it. I've gone through the voir dire process several times from the other side. So, chapter 12, preparing for trials. Again, I'll let you know when you need to do notes. So, who should decide, jury or judge? That's one of the issues that comes up. Do you want the jury to make a decision? Obviously, that's a right. You have a constitutional right to a jury trial that can't be taken away. But for all criminal defendants and for some civil plaintiffs, there is the issue: do you want to be heard by a judge? You want to be heard by a jury? If basically, if both parties agree, you can. I mean, a civil trial, you can actually decide if both agree. You can agree to what's called a bench trial, which means just the judge decides. Obviously, what you decide, whether you want jury or judge, is based on who you think is going to be the most favorable to what you're trying to do. And sometimes that can be a race or ethnicity issue as well, too. Sometimes, obviously, in some areas, a minority group person might feel like that they cannot get a jury that's like, that represents them the way they want to. And judges appear to be less risky. So sometimes that happens. Harry Calvin and Heinz Seisel in 1966, they did a big study that was a survey outcomes of jury trials. In criminal trials, they found that judges reported their verdict would have been the same as the jury is about 75% of the time. But you would like to think that would be 100%, but it's not. Similar numbers for civil trials. So there's obviously differences in judge and jury differences. About half of the disagreements between what judges would do and what jurors would do is what Calvin and Zeisel called jury sentiments. Have to do with the jury's perception of whether they believe the crime is too trivial for the punishment, or at least for the expected punishment. And sometimes they find the defendant not guilty, not because they really believe they're not guilty, but because they don't want them to be punished in the way that they thought they might be punished. Sometimes the jurors might feel that the defendants have already been punished enough, and there's no more reason to do anything else, because sometimes people may have spent time in jail. Sometimes jurors are quit because they just believe the law is unfair. Well, nobody should be punished for that. All right, so I'm jumped to page 279. We're going to talk about jury selection. Still not to notes just yet. So jury selection starts with what's called the veneer, and that's basically forming a panel of potential jury members, and that's basically before potential jurors arrive at the courthouse, and which isn't even always done anymore. Sometimes now everything's done online. So your selection officials choose a panel or veneer of prospective jurors, and basically that's supposed to be random. It's intended to be random. It has to be random. It's supposed to neither eliminate nor underrepresent any particular subgroups of the population. Therefore, it's based on a random computer selection process, which is why some people may be live in some place for 10 or 15 years and never be called to be on a jury. And some people might feel like they're called every year or two. So, all right, that brings us to note time, page 281, bottom of page 281. Talks about jury selection continues in the courtroom, the voir dire process. So on the final exam, there is a short answer choice that asks you to discuss the voir dire process. All right, and this is what I was going to have the attorney do, but I'll do it. Okay, so it's a short answer question. So I'm looking for a good solid paragraph, 3 or 4 sentences. Okay, not a page or so.
What did you say, sir?
About what?
What was it? The question discussed the what process?
Voir dire.
For dear.
All right, so once the veneer is taking place, you send out your emails, send out your letters, whatever. You requested the panel of potential jurors show up. Then in the courtroom, you actually do have to go through the voir dire process, and that changes somewhat. Before that, for veneer, it was all about a random representative cross-section of the population in the area. Now it becomes more about whether jurors are able and willing to be fair and impartial. That's a big deal. Now we say fair and impartial. The reality is each attorney is trying to get somebody who is not quite fair and impartial, but actually partial in their direction. So we say fair and impartial, but that's really not what's going on. So basically by constitutional right, the defendant has the opportunity to screen prospective jurors to make sure that nobody's prejudiced against their case. And this is done through what's called the voir dire process, which is actually a French term that means to see or to say. So how the voir dire process is done varies from place to place. Who asks the questions, what questions are asked, and how they're phrased, how long they're allowed to ask questions, and whether the questions are posed to everybody or to individuals, that's left to the judge. The judge gets to decide that, not the attorneys. So what are some of the processes here? Well, the book talks about on page 282, talks about the social desirability effect. In other words, people when they're answering questions. Well, as you probably could guess, there are some people when they're trying to answer questions that will get them kicked off, right? They don't want to miss work. They don't want to serve in the jury. They don't want to miss their trip or whatever it is. I've had more than one jury summons that took place at just about the worst possible time you can think of. And so some people are seriously trying to get out of that. And so they're answering questions to try to appear stupid or prejudiced or whatever. But most people operate under the social desirability effect, means we want to appear to be in a positive, socially desirable way. We want people, especially high status people, like a judge, like attorneys, we want those people to think well of us. And so we answer questions in a way, not necessarily totally truthful, but try to make ourselves look better. So most actual voir dire procedures involve some sort of compromise between long and short. As a general rule, both the attorneys and the judge pose questions. Sometimes the judge may not pose questions at all. I've never actually heard the judge pose questions. It's pretty much the attorneys. And then once all the questions have been asked, then each of the attorneys gives a brief follow-up of questions, sometimes particularly selected individuals, and the judge may have something to say too. All right, so why might you not be selective? Page 283 talks about challenges for cause and peremptory challenges. So the book says, technically, the opposing attorneys do not choose the jury. Rather, the attorneys are given the opportunity to exclude potential jurors from the jury. You come in there with a number, like if you're in a veneer of 60, then your juror number 1, 2, 3, 4, 5, 6 through 60. And basically, the first 12, let's say, depends, the first 12 people that are listed are going to be on the jury unless they're excluded. So the attorneys don't get to say, okay, out of these 80 people, I picked 12 people. They are basically saying who they did not pick. If they don't do anything, the first 12 people are in. So if you're in there, if you're number 60, you're usually pretty safe. Sometimes you may never get asked a question. But if you're up there in the first 10 or 15 or 20, you got a good shot at being selected. So there are two mechanisms. They're called challenges. There's challenges for cause, and there's peremptory challenges. And that's how the attorneys can exclude, or the judge can do it too, can exclude people from serving on the jury. In any particular trial, it's possible for each side to claim that particular jurors should be excluded because they're particularly biased or prejudiced, or because they have some relationship to the parties or the issues that creates at least an appearance of bias. And those are known as challenges for cause. I was in one, going through the voir dire process one time, and I think I was excluded because they asked, they always ask you if you know any of the attorneys or if you know either side. And in this particular case, I said, well, no, but my wife knows, this particular person. And I think I got excluded for that reason, okay, which is interesting because I probably was excluded by the other side because they thought I would have been more likely to be in the favor of the people that my wife knew. The reality was I was pretty much against them from what I heard. So, but you never know. It's a risk, okay? In theory, each side has an unlimited number of challenges for cause. As long as you can prove somebody shouldn't be there, there's no limit. In reality, actually, very few jurors get excused for reasons of bias. That's challenges for cause, and those can take place. Okay, for example, let's say you're there for a lawsuit where somebody is suing their insurance company because they were severely injured in an accident. They didn't get the money they were supposed to. They thought they were supposed to. And then they'll ask you, have you ever been involved in this sort of situation? If somebody says, yeah, I was in an accident one time and my insurance company didn't pay me either, you can be sure that the attorney for the insurance company is going to exclude that person. Now, those are challenges for cause. You have to demonstrate why they should not be on the jury, and the judge has to agree. Now, each side also can exclude a designated number. This is not unlimited. A designated number of prospective jurors without a reason stated, without inquiry, and without being subject to the court's control. Those are what are called peremptory challenges. You do not have to explain why you pull the person, but those are not unlimited. You may only have like 3 or whatever. Okay? Kind of like soccer substitutions in professional soccer, you're limited. Okay. Now, how many peremptory challenges each side has varies from one jurisdiction to another, and also is different from a civil case to a criminal case, and a criminal case would be different between, say, a murder trial and a burglary trial or something. There's a number of purposes why peremptory challenges are there. First, that allows them to basically exclude potential jurors they think would be unsympathetic for their client, doesn't matter why, okay? It also has a symbolic function. When parties in a lawsuit are deciding the outcome, that may make them feel better about the outcome if they feel like some people have been taken away. And then the third function, which is a really interesting part, in my opinion, because I think y'all said none of you have ever been through the process. Is that correct? Anybody ever been in a jury selection situation?
No.
No.
I used to
I haven't.
do jury.
You did what?
No.
No?
I used to do jury. Like I used to work at the district clerk's office and I'd go to the court and call out the names and I was able to sit down and listen to them.
Oh, okay. So you have seen a lot of the process. Okay.
Mhm.
And you know, like Vernier and Vernier and that whole thing. So, all right, that's good. Okay. All right. Well, basically, the third function, which I always thought was interesting, was the attorneys use this also to try to already start indoctrinating prospective jurors and influencing those. Okay. They actually start the trial during the voir dire process because they start tossing out these ideas about would this bother you if you heard that, if you thought this, whatever. So they're already talking about the case. And they're already trying to get you thinking in their direction. Each attorney is trying to get you being more favorable to their point of view before you even get in there. So it sounds a little weird to me, but it's part of the process. Okay. Basically, the Supreme Court, though, has become stricter and stricter about allowing how much peremptory challenges take place. They're trying not to overdo that. Okay. All right. Let's jump over to page 287. I skipped over some stuff there. Jump over to page 287, get your notes over there. The voir dire process is going to go all the way to page 299. So, all right, talks about lawyers' theories, stereotypes, in search of success. Okay. The book says in everyday life, our impressions are basically, psychologists say, come from what are called implicit personality theories. And implicit means it's kind of hidden, it's kind of lower level. An implicit personality theory is basically each of us has this network of preconceptions about how certain attributes are related to one another, about behavior, stuff like that. And trial lawyers often use their own personality theories to jury selection. And those can lead to stereotypes. As I said, I think I was excluded at one time just because I said my wife knew one of the people involved, when the reality was I didn't know him and it didn't make any difference to me anyway. So if you turn to page 288, another common attorney strategy, it says it's based on the assumption that if a juror is similar to the litigant or the defendant, whatever, ethnicity-wise, whatever, background-wise, what part of the country from, whatever like that, they're similar, then they're more likely to favor that litigant. That's what's known as the similarity leniency hypothesis, which has some truth to it too, but related to that, the book talks about something called the black sheep effect, okay? As a general rule, it is true that people tend to favor individuals who are part of whatever they perceive as their in-group, whether it's Texas Tech fans or whatever. But sometimes the in-group thing works in the other direction. If you identify with somebody as part of your group, then basically that means you may want that person to be severely punished because they reflect negatively on your group. That's called the black sheep effect. So it can work the other way. It actually work out where if you feel like this person's related to you in some way, you want them punished because they make you look bad. So that's called the black sheep effect. That's in there too. That's interesting as well also. All right, let's jump over to page 293, okay? Talks about pretrial publicity, okay? Which is kind of part of this. One of the things that they would do in the voir dire process is they would ask you what you know. Have you heard about this case? Did you hear about that? If you did, what do you know about it? So sometimes things are high profile and everybody knows about them. A lot of times that's true in a lot of criminal cases. Not always true in civil cases, but it can be. And so that's a big issue about pre-trial publicity, what difference it makes, okay? Studies indicate that jurors who have been exposed to pretrial publicity are more likely than those not exposed to favor the prosecution and prejudge the person as guilty. So in a criminal case, they're more likely because they've heard all these bad things about what happened, and that's a pretty standard thing. All right, jump over to page 298 and we'll finish up this section. So what are some of the remedies for, for the effects of pretrial publicity? Book lists 4 possible ways of doing this. One is a continuance. A continuance is when the trial was scheduled for a certain time, but now it's going to be rescheduled, postponed to a later date. The idea behind a continuance is this is fresh in people's minds. If we wait a while, then it won't be so fresh in their mind, the publicity will fade away. And that may be, my experience has been, people as a general rule don't get to trial very fast anyway. So, but that's a possibility. One is an expanded voir dire. In other words, we're going to have to be much stricter, much more involved, kick more potential jurors out, may even have to go more than one voir dire. Maybe out of our first 60 people in the jury pool, we couldn't come up with 12 people. We got to bring in more. That happens sometimes. Judicial instructions is the third one, okay? That basically the judge just needs to explain more clearly to the jurors about what they should not do. The book says on the basis of existing research, though, none of those work very well. Delaying the trial doesn't make people forget. Asking more questions doesn't necessarily solve the problems, and the judge telling people what to do doesn't. The fourth one's called a change of venue. That's the most likely to work with the most extreme. Change of venue means we're not going to have the trial here. This is a Lubbock trial, but we're going to go to Amarillo. We're going to go to Abilene. Obviously, that can be very expensive. It's not very convenient, can be time consuming. As a general rule, judges are not likely to do that, and that's their right. Anytime the judges make decisions about that, that's their decision. If it's a wrong decision, or you can prove it's a wrong decision, you would handle that when you demand a retrial or you appeal to some higher court. All right, anything on chapter 12 before we go to chapter 13? So again,
No,
that's it. Yes.
No, sir.
That's a short answer question. So again, we're just looking for a paragraph, 3, 4, 5 sentences, good solid paragraph. Give me longer, I can give you some extra points, but that's all I'm looking for. All right, chapter 13 is jurors and juries. And basically, there is an essay choice, which is page 302 through page 322, which is essentially the chapter, okay, except for what we don't cover. So that question, that's an essay question. So now I'm looking for a page or so, and it just says, discuss the jury decision process. I'll say that again. Discuss the jury decision process. How does a jury go about making their decision for whose side they choose, or innocent or guilty? Everybody got that down? All right, that's an essay choice. That's basically the chapter, chapter 6. Essentially, you now have all of the short answer questions. There were only 6 short answer questions on the final. You have to answer 4 out of the 6, and you can't answer a 5th. The essay, there will be 8, so we got 2 more to go after tonight, and you have to answer 5 out of 8. Okay? And you may answer a 6th one for extra credit. So there's lots of opportunities for extra credit on the exam. You can do an extra essay, you can do an extra short answer. I don't know any reason in the world why everybody shouldn't get out of here with an A. Okay, right now, your papers have been bouncing around A, and so fundamentally, you should be pretty good. Just give me a reasonable test, and you're right. All right. So chapter 13. So again, essay choice, jury decision process. Okay. All right. The book says that 1 out of 3 Americans will serve as a juror at some point in their lives. Statistically, okay. I've been once. Okay. So basically, a trial by jury is actually the only right that appears both in the main body of the Constitution, in Article 3. Article 3 is on the judicial branch, and the Bill of Rights. It's the 6th Amendment for criminal cases, the 7th Amendment for civil cases addresses that. The Supreme Court has basically nearly increased almost any contested fact that increases the penalty for a crime that must be determined by a jury. So, all right, so let's jump over to page 304 says, how do jurors think? Okay. So basically, a lot of research has been done over the last bunch of years in looking at the jury, trying to be scientific about looking at theories and principles of social psychology. This is social psychology. Things like stereotyping, attribution, social influence, conformity, small group behavior, and then in cognitive psychology, memory, reasoning, judgment, decision-making. Everything that could possibly be studied in any scientific way at all has been studied in some form, okay, to try to figure out how jurors think. So there are a couple of major questions that occurred. First question starts in the bottom of page 305, says, are jurors competent, okay? In other words, can jurors actually do what it is that we and the people involved in the trial are asking them to do? Can they carry out their duties properly? Psychologists basically, in their studies, recognizing in both criminal and civil cases, basically jurors do tend to pay a lot of attention to the evidence, which is what they're supposed to do, okay? That's called evidentiary strength. The most important factor in what jurors decide is evidentiary strength, which is supposed to be. That's why they're there. The attorneys from both sides are presenting evidence in favor of their side and against the other side, and that's what the jurors are supposed to look at, not really anything else. Part of that, of course, is expert testimony. That's a little bit of a controversial area. As our societies become more and more involved, you know, there was a time, say 200 years ago, when pretty much anybody knew what everybody else knew about what was going on in their culture. Our society is much more specialized. Massive amounts of knowledge has accumulated, continues to accumulate rapidly. And so now you see a lot more reliance on judicial processing in both criminal cases and civil cases with what are called expert witnesses, which many times can be psychologists. All right, so one of the big issues here, top of page 308 says, just got my mouse getting away from me there. One concerning issue the book says is whether, not every juror is analytical and logical and able to do that. Because a lot of jurors don't have those skills, then they tend to less systematic, less analytical, less logical, just whatever comes easy, okay? And how they look at expert testimony and how they look at the peripheral aspects or superficial aspects of the testimony. Things like if it's an expert, you know, where is an expert from Harvard or an expert from Podunk College or whatever, what they look like, what's their personality, how they talk, all those things, rather than actually what the person says. That's unfortunate, but that's kind of a factor of human behavior. That's part of the whole thing with psychology and the law. We already mentioned the idea of instructions. If you look on page 310, it talks about jurors' willingness to apply their instructions, okay? We already said the idea of what the judges tell people doesn't necessarily get paid attention to. So two issues that have to do with jurors' willingness to apply instructions. First is, are they going to follow the letter of the law, which the judge is going to explain to them what the law is? Are they going to actually follow the letter of the law if it violates their own sense of what's fair, what's just, and what would be a fair verdict? The second is the whole thing like publicity. Is it possible in our day and age with cell phones and basically iPads and things like that, is it really possible to tell jurors they cannot have anything to do with online media during the trial? And can you keep people from happening, or are people going to do it anyway? So the first question has to do with what's called jury nullification, okay? Jury nullification says, okay, you told us what the law was, you presented the evidence to us, but we're not going to follow that. We're going to acquit the defendant anyway, even though you demonstrate all this stuff too. That's called jury nullification. They basically just wipe out what's going on there. You jump over to page 313, it talks about the effects of extra legal information. So as a general rule, as we already said, jurors do tend to look at the evidence, okay? And they do a reasonably good job as long as you don't get into the other issues there. But jurors are also affected by irrelevant information, such as what the defendant looks like, the handsome or beautiful person coming in, look, well-dressed and all that. Does that affect you? They're affected by what they read in the newspaper, see online, and other sources of extra details. Those are called extra-legal factors. Okay, according to the liberation hypothesis, that's on page 313. That's Calvin and Zeisel again. We talked to him earlier. They said in the book there, it's in the book, you can read it, when the evidence in a case clearly favors one side or the other, then juries will decide the case in favor of the side of the stronger evidence. Okay, so if it's a very clear case, then it's clear to everybody. Now, if it's not so clear, that's ambiguous, right? Where it looks like both sides are pretty evenly balanced, then the jurors are liberated to go back to their personal assumptions, sentiments, and biases. In that case, extra legal evidence makes a difference. All right, so let's look at specifically extra legal evidence. Turn to page 314. Talks about the impact of extra legal evidence, extra legal information in criminal trials. All right, so we'll look at that first. Look at prior record evidence. I think we already talked about the fact that in most criminal cases, as a general rule, jurors are not supposed to be exposed to prior record until the sentencing phase. There's exceptions to that, but as a general rule, that's not true. So once jurors do hear about the defendant's prior criminal record, then it becomes more difficult for the juror to be totally unbiased, okay? They're supposed to rely only, in other words, the person's not on trial for their past record, they're on trial for the current thing they were supposed to have done. And that's what the jury's supposed to look at. They're supposed to look at the evidence about that. But once they hear about that other stuff, or they already heard about it, then it becomes more difficult for them to do that. So in that case, as a general rule, the prosecution many times is not permitted to introduce evidence of the defendant's criminal record because they would be prejudiced by that. And basically, they're judging the person on the current offense by previous misdeeds. Now, the trick here is, so that's generally true. There's exceptions, but as a general rule, we talked before about some exceptions. As a general rule, prosecution cannot do that. Now, if the defendant agrees to testify, then they open themselves up to being questioned by the prosecutor about certain types of criminal involvement. That's basically done to what's called impeach their credibility as a witness. In other words, it's saying we can't really trust this person because of what they've done. In that case, the judge can issue what the book calls limiting instruction to the effect that the evidence of the prior record can only be used for certain specific purposes only, okay? Only to judge the defendant's credibility, not to prove they have a propensity to commit that type of crime. So, as the book says, a criminal with a prior record has three choices. Choice one, bad. Choice two, bad. Choice three, bad. They're all bad choices, okay? One choice is to take a plea bargain, regardless of actual guilt. Whether they're innocent or guilty, whatever, doesn't matter, because they're afraid if they go to trial, they're going to be found guilty anyway. They can agree to go to trial but not testify, but that looks bad too. If the defendant's not willing to testify, the jury is kind of prejudiced by that as well too. Or the third possibility is testify and take the risk that during the during the examination, the jurors will learn about their prior record and be more likely to convict. So none of them are good. Okay. So what about the impact of jury injury severity and liability judgment? Now we're going to civil cases. In a civil case, one of the big issues that the jury has to decide is who's responsible for the harm that was suffered. There wouldn't be a trial unless some sort of harm was suffered. Whose responsibility is it? And that's a tricky thing to decide. One of the most difficult issues in juries is how they go about assessing damages, when the reality is that's not really most of our expertise. If you do have expertise, by the way, you won't be on the jury. I guarantee you, they try to kick off people with expertise. You'd think they would want people in there who knew what was going on, but nope, that's going to get you off. All right, page 316 talks about, can jurors disregard inadmissible evidence? You've all seen movies and TV shows, where something is said and the other side objects, and the judge says you'll disregard that, okay? But really, can you disregard something that somebody just told you to disregard? Probably not. Draws your attention to it. Okay. So when jurors are told to do that, can they do that? Inadmissible evidence is evidence that's presented in court that is basically unrelated to the substance of the case. And when the judge says that's inadmissible, that usually gets people attention instead of getting rid of it. Okay, bottom of page 317 starts a section on our jurors' bias. So we've been talking about, can jurors make, are jurors competent make decisions? Now we're talking about a juror's bias. Okay? One of the big concerns about that is, again, we put a person on the jury based on the assumption that they can put aside any preconception or prejudices they have and just listen to the merits of the case, whether it's civil or criminal. Obviously, if jurors cannot do that and they admit to that, then they would be excused for cause. But sometimes prospective jurors have ties to defendants that could influence their ability to be impartial, one way or the other. Okay, it's just like the old thing about, I'm a soccer referee, and you always hear the line about hometown referees. Because I do a lot of, teams coming from places like Amarillo and Abilene and San Angelo and Hobbs and stuff like that, and you'll hear the hometown referee thing. You're just helping the people out because your hometown. Well, that can work the other way too. Guy walks in, lady walks in, they're coaching their team. I don't know them. They may be going against a local Lubbock team that has a referee, has a coach I know is a jerk. Okay, I'm going to try to be impartial, but the reality is it can work the other way. Same thing can work here. Okay, ties can work either way. You can know somebody and like them. You can know somebody and not like them. But courts operate on the assumption that attorneys can through the voir dire process, they can identify and get rid of prospective jurors who would not be able to fairly come up with a solution. That's the idea. So you have a fair and unbiased jury. For a number of reasons, that's probably not that true. First off, as I already mentioned, attorneys are not really looking for fair and impartial jurors. They're not. They're looking for jurors that are biased and prejudiced towards their side, not people that are neutral. Second, it's almost impossible for somebody to be entirely free of your biases and prejudice in the past. That's just not really possible. That leads us to what's called the inevitability of juror bias on page 318. A lot of biases in psychology we say are inevitable. Okay, that's the term juror bias, which has to do with the idea that no matter how hard we try, we're going to interpret the information presented to us and understand it based on our past experience. That's just how we operate. That's how we're going to do that. Okay? So there's not too much of a way around that. All right, that is actually all I have on that chapter. So again, if you're going to answer that question, then you might want to go through, add to some of the notes I have, and build up a good page or so long answer to that question. All right, anybody got anything you want to talk about before we go? So Alma, I got your paper last week, and Raven, I got your paper earlier today.
I just sent mine in.
You just sent it. Okay.
Yes, sir.
All right.
My Wi-Fi was off earlier.
Okay. Anybody got anything? Otherwise,
No.
Be back here next week, same time, same bat channel, same bat station, same bat time. That's way before y'all's time, I know. All right. Okay.
All right.
God bless you guys. Have a great week.
Thank you, you too.
Thank you.
Bye.
Bye.